Morning, everyone, and welcome to episode 11 of our quarterly on-site webinar series. We've got a packed agenda for you today, including a external speaker, Mark Enzer of Mott MacDonald. I recently had the privilege of attending a workshop where Mark spoke on systems thinking in the built environment, so I have no doubt that you'll find what he has to say very interesting and thought-provoking. Before we begin, you'll have an opportunity to pose questions to the panel at the conclusion of the speakers' presentations. And you can pose those in the chat room, in the chat function. And there are just a couple of housekeeping points. All microphones and videos will be disabled during the webinar and will remain disabled. And the webinar will last for no longer than an hour, and it is being recorded should you wish to watch it again. Without further ado, I'm now going to hand over to our first speaker, Mark Enzer.
Thank you very much. Thank you so much for inviting me. It's a real pleasure to be with you, and I'm very keen actually to share this this kind of opening thought with you around systems thinking in the built environment. And what I'm hoping to do is get us thinking a little bit differently about what the built environment is and maybe what we should do with it. So given that I've not got a huge amount of time, what I thought I'd do is get straight into saying how I thought I'd do this. So the running order is very simple. We'll start with a why. Why is systems thinking so important? Why now? But also, what is at the heart of systems thinking? What is it that we're talking about when we say systems thinking? And then, very briefly, how we might apply systems thinking at different levels in the built environment. So let's start first by defining what we mean by the built environment. Like, what on earth is it? And I think a way into it is by considering the various different components of it. So there's our economic infrastructure, that's our energy, transport, water, waste, and telecoms. Now, what you'll know about each one of those is that they're each complex and interconnected, but they also depend on each other. So transport, for example, doesn't work without energy, energy doesn't work without telecoms, telecoms doesn't work without energy. You get the picture. It's very interconnected and interdependent. Then there's our social infrastructure, so hospitals, prisons, schools, all the municipal buildings, but also residential, commercial, industrial, none of which make sense or even work unless they're connected into the economic infrastructure. And then there's a complex connection as well into the built environment, into the natural environment, because always the built environment exists within the natural environment. So when you add all of that up, you get the whole built environment. And I'd like to suggest that it is therefore a system of systems. Not everyone likes that language, but I think it's just a matter of fact that all those systems connected together mean that the built environment is a system of systems. And it's something that we utterly depend on. Because if the built environment doesn't work, then society doesn't work. And quite often we don't notice it because it's hiding in plain sight because we live inside it. So that's our built environment. It's super connected. The trouble is that the way that we run it is very often in silos. And so you see these silos going all the way kind of top to bottom, from ministers through regulators, through the arm's length bodies. You get the picture. And quite often we're not good at communicating across those silo boundaries. So that doesn't work if you've got a very connected system, but disconnected organizations trying to run it. It's not the end of the problems because we also have very connected challenges, not least of which is climate change. We know that's real. We know it's happening. We know that we're responsible for it. But it doesn't happen in silos, and therefore you can't solve it in silos. And the thing is, climate change is not the only kind of cross-sector challenge we have, because if we want to achieve net zero or provide climate resilience or move towards a circular economy or protect biodiversity, all of these huge, great big challenges happen across the whole system. Like I say, they don't happen in silos, so you can't solve them in silos. And even at this kind of global level where we're thinking about these huge, huge problems, the built environment does matter. You might have heard that a couple of years ago we passed a tipping point where the total mass of the built environment exceeds total biomass. The built environment also is the biggest user of natural resources out of all human activity. It's also accountable for something like 60 or 70% of carbon emissions. So at a global scale, the built environment matters. What I would say is that that also means that we matter, because we are the ones who can do something about it. And I do believe that even though these are really big issues we're talking about, we have agency and we can do something, but we can only do it if we're joined together. So let me summarize where I think we got to as a problem statement. We've got super connected systems, and we've also got very connected challenges. However, we've got siloed organizations that try to address it. And even if the organizations somehow got their act together and were more connected, they still wouldn't be able to do their job, because we've got siloed data. The data they need to do the job is also in silos. So basically, we've got a big problem, because the built environment is getting more complex and more connected, particularly as we decarbonize and we digitalize. We're making more connections. So this issue that we're talking about here is becoming more serious. And in the built environment, because of its very nature, because it's so long-lived, we need to have an approach which is strategic and long-term and joined up. And I think that if we're honest with ourselves, the way that things have been over the last few decades has been none of these, neither strategic nor long-term nor joined up. So we've got a problem. However, there are solutions. And this is where I'd like to bring in the idea of systems thinking, because systems thinking is about joining things up. It's about connections. I think that's not enough, though. It's not enough just to bring in a new way of thinking that will help to unlock some clever solutions. I think we also actually have to drive some positive systems change. It's not just enough to do some systems thinking, we've got to change some systems too. And so thankfully, there's lots of approaches which are ready to go, because systems thinking isn't a new thing to humanity. It might be a new thing to the built environment, but whether we look at systems science or cybernetics or systems dynamics, all these things have existed and have been proven and used elsewhere in human activity. What we now have to do is bring the best of those to the built environment. And I think that if we're going to do this, we kind of need to know a destination. Where are we going to? Where are we trying to aim for? What's our vision? And what I'd suggest in this space is for us to see the built environment as having a purpose, and that purpose being to enable people and nature to flourish together for generations. What you'll probably see in that statement is it's really a restatement of sustainability, but I think it's a good restatement, because what it recognizes is that the built environment as a whole, as a system of systems, has got a purpose. Now, this is not how we see it normally, because I think very often how our industry sees the built environment is as a series of construction projects, and we just focus on the project. So we need to move to a different place where we can actually see this bigger picture. And the way that I would summarize very quickly how we see that bigger picture is actually to start with the outcomes, see what it is we're aiming for. I think at a global level, the Sustainable Development Goals, the SDGs, are a really good articulation of what we as humanity want, but that's global. What we have to do is bring that down to local, so that our local outcomes align with the global ones, and then they can be achieved. Then we have to see how the systems we have can deliver those outcomes. And the systems we have to play with are the built systems and the natural systems. And then within those systems, there are a number of levers that we can pull to try and improve the systems to deliver the better outcomes. It sounds very simple, but it's not kind of as easy to do as it is to say. And part of the reason is because of those disconnections that I talked about before, the disconnections between organizations and the disconnections between data. But this is the picture that I think we need to move towards. It's a real focus on outcomes, being super clear on what we're trying to achieve, so that then we can understand the systems better, intervene more effectively, and deliver the outcomes that we all want. It's not how it happens at the moment, because generally what we do is focus relentlessly on the projects. Now, projects are good things. I'm not going to say a word against projects, because projects are the best way of getting stuff done. However, if that's our only view, if that's all we see is the picture from planning through design, build to handover, then we don't see the bigger picture that can actually deliver the outcomes which we need and address those big challenges that I spoke about before. So how to apply systems thinking? If we think it's a good idea, And obviously, I'm not going to get this all covered in 10 minutes, but just an overview, because it is possible, I think, to apply systems thinking at any level within the built environment. And the first step is to know what we're talking about, know the scope. Just define the scope a little bit. Are we talking about the whole country or a city or part of the rail network? It's just know the scope, what you're talking about, what are you trying to achieve? Then it's all about defining the outcomes that you want from that system. And we do know, don't we, that systems are always part of bigger systems. And so you can never kind of define the whole thing. It's just important to get started, draw a boundary, see what's there. But clearly the outcomes relate to the system that you're looking at. And then having defined the outcomes that we want, that effectively drives all the rest of the change, because what I think we will almost always see is that the outcomes we're currently getting from the current systems are not what we want. And therefore, when we identify the outcomes that we do want, there's a delta, there's a change between what we have and what we want. And therefore, it drives us to firstly understand the system better. That means, yes, some participatory system mapping, but also some visualization of the system, understand how things are connected, particularly how the systems connect to the outcomes. And then we can do some modeling, etc., which then enables us to do the interventions, our projects. And then we have to observe, learn, and repeat. So it's very simple. Each one of those numbers there has got a whole load more stuff that we have to do, but it's all doable. And I think in an industry that has relentlessly focused just on the triangle, we now need to be in a space where we focus on the triangle, the circle, and the square. It's a simple message. And so the key takeaways, the key things I'd like to just kind of leave you with from this really quick scoot through is that I think it really is time now to see the built environment differently, not as a series of construction projects, but as a system of systems that has a purpose to enable people and nature to flourish together for generation. And it's not just a nice concept anymore. This is screamingly urgent, because we're making things so complex that the systems we currently have literally will not be able to cope with what we have unless we make some change. And I think the kind of change we need to do is build a consensus around systems thinking, which then enables communities to drive the actual change. And so what I'll leave you with is that thought, and hand it over to Stephanie.
Thank you, Mark. That's really interesting. Good morning, everyone. My name is Stephanie Giesing. I am counsel in the dispute resolution team in London, and I specialise in construction disputes. So I've got 10 minutes this morning just to quickly talk to you about the Defective Premises Act, and I will be doing so specifically in the context of fire safety defects. So getting straight into it, I will start with an introduction to the Defective Premises Act, or the DPA, changes to the DPA following the Building Safety Act, what the recent case law is telling us about how the courts are approaching claims under the DPA, and then concluding with some key takeaways if you are thinking about bringing a claim or indeed potentially defending a claim. So first things first, what is the DPA? So the DPA was enacted to tackle the perceived injustice where subsequent owners struggled to bring claims against the original developers or contractors. So it was really a mechanism for owners to bring a claim. What we're looking at today, specifically within the DPA, is Section 1 of the DPA, which itself is quite wordy. I haven't put all the words on the slide here. But the key points to note on that is that Section 1 states that the duty holder must carry out its work in a workmanlike or professional manner, use proper materials, and that the dwelling must be fit for habitation when completed. So in order to successfully bring a claim under Section 1 of the DPA, you have to show that the work was not carried out in a workmanlike or professional manner using proper materials, and that the dwelling was unfit for habitation when completed. So it is a composite single duty in that sense. And as I mentioned, we're really looking at this through the lens of fire safety defects. So it's worth noting that very generally speaking, fire safety defects are likely to fall foul of Section 1 of the DPA, obviously depending on the exact nature and extent of the defects. But even if the building is still occupied, we do think that these are likely to give rise to DPA claims. And it's also important to note that parties cannot exclude or restrict the effects of the DPA. So that means you cannot contract out of the DPA. So as I said, the DPA came into force in 1973, a long time ago, and it's not something that we've really looked at a lot in the context of claims as between developers, contractors, and their supply chain historically. But that all changed when the Building Safety Act came into force a couple of years ago. So the Building Safety Act introduced significant and retrospective extensions to the limitation periods for bringing claims under the DPA. So historically, the relevant limitation period for bringing claims under the DPA was 6 years from the date of completion. But Section 135 of the Building Safety Act changed that. The wording's on the slide there, but it's probably easiest just to look at the next slide where I've put in a table. So for works completed before the 28th of June 22, so historic projects, there's now a limitation period of 30 years from the date of completion. For works completed on or after the 28th of June 22, we're looking at a limitation period of 15 years. So you can see that that is a significant shift from the 6 years we had previously. This doesn't apply to claims that have been settled or finally determined, so they can't necessarily be reopened to now bring a claim under the DPA. But you will appreciate that this has had quite severe consequences for the industry. So it's important to remind ourselves of the policy reasons as to why we now have these extended limitation periods. And really, it all comes down to improving building safety following the Grenfell Tower disaster, and specifically addressing historical building safety defects that might have previously been overlooked or not properly considered, and making sure that there is an avenue to bring claims where appropriate. So there are strong policy reasons behind the extension of the limitation period here. So if we look very quickly at the impact of the extended limitation periods, there are some interesting numbers that speak for themselves. So in terms of DPA claims before the Building Safety Act extended the limitation period, there were about 133 reported judgments. Since the Building Safety Act came into force, we've got about 28 roughly so far. So that means an annual increase from just shy of 3 judgments a year to just over 9 judgments a year. So that's quite a significant increase. And definitely it's something that we don't think is going to change anytime soon. There are so many claims of this nature currently in the pre-action protocol and making their way through the TCC. If anything, we suspect that number might go up. So why are we talking about the DPA now? So I've already kind of hinted at it by referring to the extension of the limitation periods introduced by the Building Safety Act. But historically, DPA claims weren't really explored as between developers and contractors in the supply chain, especially in circumstances where there was the ability to bring a claim under a contract or a warranty or in tort. That was generally preferable, perhaps because the fitness for habitation is a slightly higher hurdle than those other claims. So it's not something that we really dealt with a lot before the Building Safety Act. But now, of course, because of the extension of the limitation periods, it means that it might be the only cause of action left. Claims for breach of contract or in tort may now be time barred. So that's why the DPA is something that we're looking at a lot more closely now and getting a lot more guidance from the courts on as well. So it's the extension of limitation periods really, and the potential that this is the only cause of action that's driving this, but also just generally in the industry, there have been a lot more investigations into defects, specifically fire safety defects. There's a much better understanding of the consequences of the severity of these defects and the need to carry out remedial action promptly. And so there's an increased awareness of these types of defects, the consequences, the remedial works that are required, and the DPA. So that's the reason why we're looking at this more closely now. So moving on then very quickly, just to canter through some of the recent cases. The first one I want to look at is a Court of Appeal decision from, I think it was June or July 23. And there's 2 interesting points that come out of that are worth noting. The first is that it clarifies that developers are owed, as well as themselves owing to subsequent purchasers, a duty under the DPA. So what that means in essence is that a developer can bring a claim under the DPA against a contractor or consultants under Section 1. So it's clarifying the potential class of claimants that can bring these type of claims. The second point is that it's open to parties in ongoing litigation to amend their case to revive previously time-barred defects claims under the DPA. So in this case, proceedings were issued before the Building Safety Act introduced the extended limitation periods, but after that introduction, the case could be amended to include such claims. So I mentioned earlier that if a claim has been finally determined or settled, you can't reopen it, but obviously that's different if you've got ongoing proceedings. So it's worth noting with this case that after the Court of Appeal decision, as I mentioned a couple of years ago, it has now been heard in the Supreme Court. That was in December last year. So we're expecting the judgment on that any day now, perhaps. So this might all still change. So watch this space. The next case I want to quickly touch upon is not a fire safety defects case at all, but there are still some points that come out of it in terms of how we apply the DPA that will be relevant to such claims. So first of all, I mentioned that liability under the DPA cannot be restricted or excluded. And in this case, it was confirmed that that also applies to net contribution clauses. So it's not just a case of not being able to put a provision in your contract that says the DPA doesn't apply, but also if it has the effect of restricting or limiting the application of the DPA, that also won't be upheld. The other point is to do with damages. So the damages that can be recovered are those to put the property into the condition it would have been in had the work been carried out in a workmanlike or professional manner. So essentially what that means is that from a quantum perspective, in terms of the costs that you can claim as part of a DPA claim, you're not just limited to the costs of making sure that the dwelling is fit for habitation, but there might be other breaches as well that come into it. So in this case, there were specific design obligations and the costs associated or the losses for those breaches could be considered as part of the quantum for a DPA claim. The other point is more of a question of whether liability under the DPA is strict. So this is something that was spoken about quite a bit before this case, and generally there were a lot of notes suggesting that actually it was strict liability, and there was definitely guidance produced around the time that the Building Safety Act was making its way through Parliament, and before it came into force, that suggested that as well. Those guidance notes have now been withdrawn, not specifically because that's no longer the position, but they have been withdrawn. And there's been some commentary following this case that perhaps actually liability under the DPA is not strict based on how the judge approached it. So it doesn't deal with the issue head on, but again, it's an important question that needs to be clarified within the industry. And then the last case I just want to quickly run through is a more recent case. For context, it started life as an adjudication that was started about 20 years after practical completion. So making use of those extended limitation periods. And the court held that that was fine. DPA claims of this nature can be referred to adjudication. For those of you that have been involved in an adjudication before, you'll be aware that you're dealing with incredibly tight timescales to get to a decision. So you can imagine the difficulties in dealing with a claim from about 20 years ago in that context. The contractor has been given permission to appeal. So again, watch this space. It might be the case that that position changes as well. So just to conclude very briefly, I'm conscious of time, but we've explored the policy reasons to maximise the applicability of the DPA, and we've seen that the Building Safety Act, along with the court's approach, are really clarifying how the DPA can be used in the terms of fire safety defects for the first time, and arguably also broadening its scope. So we've looked at expanding limitation periods, potential class of claimants, the forms for dispute resolution, so being able to adjudicate these claims, and also the potential damages that can be recovered. But that's not without its difficulties, irrespective of whether you are bringing a claim or potentially having to defend a claim. These historic DPA claims can be incredibly tricky. I've put 3 points on there, and we could probably talk about that for 10 minutes in and of itself, but just very quickly, factual evidence. If a project was completed 20 years ago, do you still have all the documents? Where are they kept? How easy are they to access and review? Relevant people who were involved in the project, have they left the organization? Have they retired? All of these things are important to think about in terms of your strategy for bringing a claim and defending a claim. Expert evidence, not specifically limited to DPA claims, but what we're seeing a lot in the fire safety space is really helpful technical opinions on, best practice remedial works that need to be done now. But that evidence, those reports are not always helpful in the context of understanding your position when it comes to a claim. So it's making sure that you're getting the right type of evidence to understand your position. And then solvency, unfortunately, still very much a problem in the industry. So before you start thinking about bringing claims, you want to be thinking about whether the entities that you're bringing claims against can actually meet these claims. I mean, some of the remedial bills are obviously in the tens of millions of pounds. So if you do bring a claim, are you likely to recover any money? So those are just some of the points to think about. But the key takeaway really is this is a rapidly evolving area. There are further important decisions on the horizon, both in terms of the cases that are going to appeal and the number of cases in the pre-action protocol and going through the court at the moment. So definitely watch this space. We regularly do updates on developments in this area. If you don't already receive them and you are interested in being added to the mailing list, please do reach out. Thank you very much. That's all we have time for today, unfortunately, but I will now hand you over to Barry.
Good morning, and thank you very much for joining us. So in the next session, I will be talking about design, but also design and build in particular. And when we plan these webinars, we look for the most relevant, most up-to-date information to bring to you. And we have 3 cases to discuss in this section, one from last October, one from November, and one from this month. And the trend that we're currently seeing in the market is an increase in cases that are design related. They not only arise out of some of the issues that we're talking about in this webinar this morning, but also more general points about construction and development. Namely, we have construction projects which are becoming more complicated. We have an increase in constructor insolvencies, which effectively means that developers may need to bring claims against other members of the professional team. There are new legislative changes. We've spoken previously about the Building Safety Act. They place new obligations on designers, and so there's an opportunity for criticism if design isn't according to the relevant standards. And also in relation to design and build contracts, which are also under the spotlight post-Grenfell Tower inquiry. And it's on this last point, the design and build contracts, that I want to speak about in this session. So by way of a recap, design and build, it's the most popular form of contracting in the UK. So this is where a developer, an employer, engages the professional team to undertake preliminary works. When a contractor is appointed after the design usually reaches a certain stage, a novation takes place with the professional team being novated from the relationship between employer and professional team to professional team and contractor. And that relationship is replaced by collateral warranties, which maintain that contractual link between the professional team and the employer that originally engaged the services. So the advantage to the employer is that the employer has a single point of responsibility for design and construction risks. So it doesn't need to prove whether an issue is design related or whether a problem is workmanship. But equally, there are some criticisms of the structure because they say it just enables an employer to offload risk from the design team, from the employer, onto the contractor, and the contractor then passes that down its contractual design chain, perhaps to parties who are least able to take on that risk. So the first case that I want to talk about is from October last year. So this is a case in which BNP contracted with a contractor, the Briggs & Forrester. The contract was JCT 2016 design and build contract. So the works were to remove an existing stair pressurization system in an office building and to upgrade that system and install a new one. Under the design and build contract, there was a dispute about the scope of works that the contractor needed to undertake, and particularly about the scope of additional services to remove asbestos. So while the works were ongoing, they identified asbestos. Some asbestos works were thought to be included within the scope of the contractor, but a larger amount of asbestos works were identified. And essentially the question was, did that fall within scope or was that outside of scope? And should the contractor be entitled to a variation as a result? There was an impasse, nothing happened. BNP refused to instruct the additional works as a variation. The works were effectively suspended for a year. And the contractor effectively terminated the contract. And the issue before the court was whether the termination was valid. And in order to decide whether the termination was valid, it was necessary for the court to look at the scope and what was included and fell outside of the contract. So the court decided, looking at the contract and the documents that sat behind it, that the contractor had full responsibility to deliver the employer's requirements. That document essentially defined the scope of the works very broadly. The employer's requirements stated that the scope of the asbestos removal included, but was not limited to, the defined asbestos works. The additional asbestos works were included within that scope. So that's the first case. Second case is from November last year. As the photo indicates, there was a dispute about works to a dairy. Again, the former contract was JCT 2016 design and build. The employer Workman contracted with ADDI to expand the facilities at the dairy. The employer's requirement said that the contractor would be fully responsible for the complete design, and the significant design had been developed to the end of RIBA stage 4. The contract also said the contractor was responsible for reviewing the design development to ensure the employer's requirements were met. So there appeared to be a potential discrepancy in the contract document, which contained these provisions in the employer's requirements, and they didn't sit with the JCT design and build contract. And so essentially the issue before the court was the extent of the parties' design responsibilities and what again was included in the scope. So the court found that the contractor was required to complete the design. There was a dispute as to whether any warranty had been given about the state of the design. They said that no warranty had been given by the employer about the state of the design. The employer's requirements place responsibility for the works on the contractor. Our final case is this month. So it's between CISC and Capital and Centric. So this is a case about the construction of some residential buildings, including the refurbishment of a mill. And in that case, the court had to decide who was responsible for the existing structures on site and for supporting those structures and facilitating the existing structure works. The employer had engaged Arab engineers at a very early stage. They had undertaken some initial review and provided some initial advice. And the contractor said, as a result, that those works sat with the contractor. sorry, the contractor said that those responsibilities sat with the employer. They argued there was a warranty, and the issue came before the court as to the extent to which the works were included within the scope. So the court looked at the employer's requirements, looked at the JCT contract and how they came together, and they said that no warranty had been provided by Arup about the state of design of these buildings. There would always be residual risks under a JCT design and build contract that wouldn't fall within the scope of the designer's responsibility. And how you determine those residual risks will be viewed by looking at the contract provisions together. When those provisions were looked at, it was clear that Arup had been employed by CNC to perform the pre-contract investigations. A novation had not yet been affected, and so the responsibility for the on-site works remained with CNC. So recap, 3 cases, both concerning design, both concerning JCT design and build contracts. So we have common issues about what falls within the scope, what falls outside, how the amendments relate to the employer's requirements, how do the documents all fit together, were any warranties provided? And in summary, these 3 cases, they illustrate that tension that we often see in design and build contracts about the works that are performed by the design team, the physical works that are provided by the contractor, what was provided before the novation, is that covered in the post-novation responsibilities of the contractor, or are there residual risks that sit with the employer? So what can we do about that? I mean, having looked at those key themes, having looked at the recent cases, what can we do to, take away and to mitigate these risks? So first of all, I think we need to be looking at the bigger picture. Is design and build the right procurement method for that particular contract? For example, there may be some projects where the employer wants to retain a greater control over the quality of the design, minimize issues relating to value engineering. In that case, design and build may not be the right procurement method. So it's worth looking at the outset, is design and build the correct procurement method for that project? It's also necessary to consider whether the benefits of design and build are outweighed by potentially the cost risk, because under design and build, you have works that may have been completed years before by a professional team being novated over to a contractor who may well price for those risks being assumed by the contractor and then passed down the supply chain. So it's worth undertaking a cost-benefit analysis as to whether the risks of the design and build structure are resulting in any adequate cost saving to the employer. The 3 cases from the last couple of months illustrate that as much care should be taken when preparing the documents that sit behind the JCT and the contract amendments as with the legal parts of the documents itself. So in these cases, we had uncertainty about what was included in the scope, what was included and fell outside the scope, were any warranties being given, and the employee's requirements part of the document doesn't always receive the same intention from the project team as the legal amendments. So these cases are a reminder that it's necessary to put as much care and effort in making sure that the employee's requirements reflect the needs of the project as the legal parts address the legal risks. And also consider the contractual allocation of risks on the project. So it's not unusual for the employee's requirements or the contracts to adopt a contractual position that is perhaps not reflective of what people are actually doing on site. So it's really important for the employee's requirements and the legal parts of the document in the JCT amendments to reflect what's actually happening on site and not to have a disconnect to where we are in reality. Other points worth reminding ourselves about. If the base design is being developed by the employer's team, so consider to what extent will it be necessary for the contractor to check that design. So obviously the contractor may have some concerns about taking on this design that may have been developed perhaps years before the contractor was involved. Will the contractor devote the time and effort to check in that design, or will the contractor feel that it has the necessary checks post-novation by having that contractual link with the professional team and then passing on that risk down the supply chain? So it's worth trying to understand a bit about the independent checks and verifications that the contractor is intending to undertake post-novation. I think also be wary about any assurances in the employer's requirements that could be construed as warranties. So, for example, there were clearly in 2 of the cases that we looked at parts of the employer's requirements where there was sufficient scope for the other side to argue that a warranty had been given, an assurance had been given about the state of the design. And that was part of the basis on which the dispute was based. Where design and build is to be most effective, it's where it provides the employer with that single point of responsibility for design and construction risks. So once the contractor is engaged, there seems little sense on the part of the employer to delay the novation. So again, in one of the cases, we had an important factor in the court's decision being that the novation had occurred. In the other decision, the novation hadn't occurred. And so those design risks still sat with the employer. So if design and build is to be effective, there seems little delay in putting those novations in place to ensure that single point of responsibility. Otherwise, you have to question what is the benefit of having the design and build structure. And a final reminder, where the design and build structure results in a project restructuring with the design team being passed from the employer to the contractor, after that novation, the employer may not have a contractual link with the design team and the professionals who carried out those pre-consultancy services. And remember, in the absence of a contractual link, it's too remote to recover the costs of physical damage to buildings. And so we maintain that contractual link by the contract that formerly existed between employer and consultants being replaced by collateral warranties. Again, make sure that those collateral warranties are put in place very promptly to provide the employer with the protection if something goes wrong, that they still have that link with the professional team, and don't leave those warranties too late, because the warranties are a powerful means by which a project can be restructured in the event of insolvency. So it's not worth leaving them to the end of the project. You actually need those warranties during the live job, so that potentially there are step-in rights to enable the project to be restructured in the event of an insolvency. So that is a very quick run through in relation to design and build and some recent cases. I'm now going to hand over to Ryland Ash, who will speak to us about defects.
Thank you very much, Barry, and thank you to everybody for joining us. So the topic of my presentation today is defects, and the reason I wanted to speak about defects is because they invariably occur on every construction project. The other reason is that I think you can draw together some of the themes from everyone's presentations today under this topic. So to start with, we're going to look at what is a defect in very broad basic terms. We're looking at workmanship versus design because they're obviously different in nature. Defects liability periods under contracts. The rights that parties have in the event of a defect occurring, including set-off abatement, and then I'll talk about irremediable defects. Then I'll mention duty to warn, and finally the remedies and some suggested solutions when dealing with defects. So what is a defect? Well, the first thing to say is that there's no statutory definition. It's very much a beast of interpretation and contract. They can arise in respect of design or workmanship. And in relation to the two things, there are different standards that apply at law, subject to the wording of your contracts. And I'm going to come back to that point in a bit more detail. But essentially what we're dealing with is the test of reasonable care and skill versus fitness for purpose, which is, if the purpose is more stringent, normally a higher standard. One thing to note on a practical level is that often insurance policies will cover for a failure to achieve reasonable care and skill, which means you have insurance-backed protection, whereas most insurance policies, if not all of them, will exclude liability for fitness for purpose. Going back to the 1800s here in Yarmouth and France, this case was about the definition of plant, and unfortunately, it involved a dead horse. The courts decided that the horse was plant because it was part of the process of the business. But usefully, in respect of defects, the courts here also set down this principle that anything which renders the plant unfit for which it was intended, when used in a reasonable way and with reasonable care, would effectively be defective. And of course, a dead horse is very much defective. That was really the starting point and laid the foundation for later definitions, which now turn into and have become the common law position, and also the statutory provision, which I'll mention in a moment. In Hudson's building, it clearly defines a defect as work which fails to comply with the requirements of the contract, and so is a breach of contract. And so you can see there that they're setting it firmly within the square corners of the contract, and therefore it's a question of whether something that's happened, whether that means that it complies with the contract or not. In terms of a statutory standard that I mentioned, if you look at the Supply of Goods and Services Act, in a business-to-business relationship, when someone is doing something in the course of their business, they have to do that with reasonable care and skill. And so that provision will be implied into your contract if it's business to business, even though the words aren't there expressly. So let's look at workmanship versus design. So in respect of workmanship, it is very clear that either at common law, if the statute provisions are being relied upon, or in most contracts, there is a provision that will say to use reasonable care and skill. So that's what we're talking about in respect of workmanship. Comparing the different contracts here, you've got the standard building JCT contract, for example, without design. Under that contract, a contractor is liable for the materials and workmanship that they've built, but only so far as they have to comply with what the contract says. And therefore, if something in the contract has specified something that is erroneous or defective, and the contractor is only responsible for building it, then they won't be liable for any such defects. Compare that with the design and build contract, where a contractor is liable not only for the workmanship to a reasonable standard, but also for the design, which includes the design itself, workmanship, and materials that have been selected for the design. If you look at the JCT contracts, they expressly include provisions that say that a contractor is to carry out, complete the works in what they say is a proper and workmanlike manner. That can be equated to reasonable care and skill in the common law. If you look at the NEC contracts, they don't have express provisions, probably because it's considered to be implied, but also because it's more about whether you've complied with the contract documents rather than some abstract standard of reasonable care and skill. But what we often see is Z clauses added to those contracts to include express wording. Under the FIDIC, again, contractors to carry out works in accordance with proper, workmanlike and careful manner. There's a question there whether careful includes a higher level of diligence, which can often lead to disputes. In terms of design then, the key point here is as set out in IBA, EMI and BICC 1980. Lord Scarman says, in the absence of any terms express or implied negating the obligation, one who contracts to design an article for a purpose made known to him undertakes that the design is reasonably fit for purpose. And so what that means is if you're designing and building something, it needs to be fit for purpose, unless the contract says otherwise. And that's why you will often see amendments to contracts where there's a design and build obligation to lower that standard down from that reasonably fit for purpose, uninsurable risk down to reasonable care and skill. And I also mention here this case of MT Hookguard, because this is a very important case dealt with by the Supreme Court in relation to the standard that a contractor needs to achieve. Essentially, in this contract for offshore wind manufacturing and installation in the ocean, it was a question of whether the foundations were defective. And within the contract, there were contradictory standards that needed to be met. One being a service life of 20 years and another compliance with industry standards. The contractor complied with the industry standards on the face of it, albeit it's transpired that those standards were unclear or inadequate. And so it fell back to the obligation to comply with the 20-year life cycle, which was a higher standard. So essentially, what the courts decided here is that if you've got different standards in your contracts, you're always going to be held to the highest standard. And for that reason, it's extremely important that contractors, designers, and of course employers, when considering specifications, understand that principle and effectively take that higher standard to be the one to be met by the contract. I wouldn't be doing the subject of defects justice unless I mentioned defects liability periods, but they are somewhat a misnomer in the sense that defects can exist during the course of the works, after the works, and right up to the limitation periods that Stephanie touched on under the Defective Premises Act, which I'm going to mention later. But essentially what you've got under most standard forms is a period of rectification after practical completion, where a contractor can be brought back to, or a subcontractor to rectify defects. It's just a process, but it doesn't change the contractual legal position in terms of those defects for which the contractor remains liable. Under Walter Lilly, a famous case from 2012 in the construction world, it was held that de minimis snagging should not be a bar to practical completion. And in the subsequent case of Mears and Cosplan, which I was involved in on behalf of the successful party, it was decided by the Court of, well, confirmed by the Court of Appeal, that irremediable defects, in this case, room sizes that were smaller than planned, did not prevent practical completion necessarily. It was a question of fact and degree. The issue there was really the measure of loss as a result. Most standard contracts include either what they call a rectification period or defects liability period, during which there should be a mechanism for rectification of any defects by the contractor. Under the NEC contract, 44.4, for example, refers to defects correction period in a similar vein, and the FIDIC refers to the defects notification period. So they're all essentially equivalent. One point I did want to draw out here, which is from following the case of Pierce and Baxter, is that if a contractor has a right to return to rectify defects, and if an employer fails to give the contractor the opportunity to rectify those defects, then it will be limited in its recovery to the cost to the contractor rather than the third party cost, as confirmed in this case, which is an important point when you're looking at what you can recover as a result of a defect. In terms of your rights, if you're the innocent party facing a defect, practically, you have to establish that whatever the issue is a defect under the contract on the basis that it doesn't comply with the contractual standards, either for workmanship or design. And then the next question is, how do you deal with that practically in the account if it's not rectified or there's a cost to be attributed? There's essentially two ways. One is by way of a set-off against the account that's being claimed. So you deduct the amount out after working out what is due. or you can apply an abatement. Normally an abatement will happen during the works, which means if someone says they think the works are 100% complete, you'd say actually because of the defect, they're really only 80% or 50% complete, and that would be a reduction in the value. And they should be captured, remember, in your payment notices and or pay less notices. It's also worth noting that under the JCT and other forms, that there's an entitlement of an employer to decide not to have the contractor rectify defects and instead make an appropriate deduction. And this issue came before the High Court in the case of Mull and Hutton, another case I was involved in. And in that case, essentially, the High Court decided that appropriate deduction means appropriate deduction, which, of course, is not particularly helpful. But what they were essentially saying is that it depends on the circumstances. So my understanding of the implications of that, as how I would apply it, is that if a contractor is given an opportunity to rectify and then they refuse or fail, you're likely to be able to recover the third-party costs as per Pearce and Baxter. And then the reverse, if they're not given the opportunity, an employer might be limited to the cost of the contractor. It's also worth mentioning at this point that not all defects should be rectifiable, or indeed should any damages be attributable to them. So in the well-known case of Ruxley Electronics and Forsyth, there was an instruction to build a swimming pool that was 7 foot 6 inches deep, and the swimming pool turned out to be only 6 feet deep. And the claim was made on the basis that they wanted to rebuild the swimming pool, the original depth. And the court said that was disproportionate, and you don't get the cost of that. All you do is get the loss of amenity, which was around £2,500. So essentially, you can't insist on every defect being rectified. There needs to be a test of reasonableness applied, essentially. I've included in here some of the processes within the NEC contract, just to compare that with the JCT and other forms. It follows a similar line. During the works, there can be an instruction to rectify a defect from the supervisor. There's also an obligation, standalone obligation on the contractor to rectify defects, even if they're not notified. So that's just an ongoing duty of care point. And there is also scope for the parties to accept defects under clause 44, which leads to some interesting questions about whether if you accept a defect, should there be an adjustment to the price where there was no intention to rectify the defect? My own view is that if it's a question of defined costs and no defined cost has been incurred, no defined cost should be recoverable, and therefore no adjustment should be made. But that is open to interpretation. When you're considering the obligation to comply with the contract, there's also the duty to warn. So even if you are an innocent party in the defective work situation, you have a duty to notify the contractor, and a contractor equally has a duty to you when they're undertaking those works. And that essentially extends to picking up on things that could be potentially dangerous to either people or the property. There's also some express provisions within the JCT, for example, about identifying or warning and notifying divergences between the contract documents during the process of the works, and they are to be notified and then valued. And under the NEC contracts as well, the provisions for early warning notices. So they're all akin to early warning or duties to warn. Under FIDIC, you've got no early warning mechanism, but I would say that it's probably implied by way of an obligation to mitigate certain consequences. And I just thought I'd mention under the Defective Premises Act, which Stephanie also mentioned, that there is an exception here relating to instructions. So essentially, you'll be responsible for undertaking the work, but there's also a duty to check that instruction is reasonable and valid, and there's nothing in there that could jeopardize people or the property. So to sum up, in relation to remedies in respect of defects, The starting point is, what is the contract specification? Is it a question of workmanship or design? Looking at those standards that you have to comply with. There's a duty on the contractor to rectify, certainly once it's been notified. If they fail, there's then an opportunity to get it rectified and bring a claim. That claim should be set out in the payment notices by way of a set-off or abatement. Obviously, there's scope for negotiation. I suggest that any such negotiations are without prejudice, so they cannot be used against you later. If it is disputed, then of course it could well be suitable to have an expert opinion opine on whether or not this issue is a defect or not. And if you cannot resolve these disputes, then remember you have the option of adjudicating on that very narrow point about that defect, or it could be the principal, it could be the value, or it could be the entire account. But ultimately, that will give you an opportunity to settle such issues. Thank you very much for listening. I'm now going to hand back to Rebecca, and I think we're going to open up to questions.
Thank you very much, Ryland. I'd like to thank all of the other speakers. It was really interesting selection of topics and very informative and thought-provoking. I realize we're a little bit over time, but I think we've got time for a couple of questions. So I'm just going to have a look. Okay, so the first one, I'm going to direct this to Barry. So the question is that the design and build contract was criticised by the Grenfell inquiry. And do you think it is still fit for purpose?
Really good question. The inquiry felt that it couldn't go into the details of procurement because it said that it was outside its remit, but there was implied criticism of design and build. And essentially that's because contractors say, you know, why lumber a good contractor with design that has been prepared years maybe before they were involved and with which they don't know about. And then designers say the restructuring of the project means that they move from a relationship where they're advising the employer to one in which they essentially lose control because they're working for the contractor and the contract administrator is administering that design and build contract. So design and build has been subject to criticism. We'll see how things develop. There's obviously several disputes in this area going on right now, so we should continue to watch for that. What some commentators are saying is that after Grenfell and the implied criticism of the design and build procurement route, we should move to an alliancing structure where you have a more collaborative approach between the design team and the contractors who work out the design options at a much earlier stage rather than dealing with this novation, you know, just before the physical works start on site, but where maybe the design has been in preparation for months, if not years before. So again, something to watch for. Was implied criticism. Let's see whether, you know, and how that pans out in the future.
Thank you. And I can see we've just got one further question here. Steph, I'm going to direct this one to you. Do the extended limitation periods that you spoke about apply to refurbishment projects?
Another good question. So what I really focused on today was section 1 of the DPA, which deals with the provision of a dwelling. The Building Safety Act did introduce a new section 2A, I believe it was, which expands the right to claim in relation to work undertaken on any part of a relevant building. So that probably includes refurbishment works. Those projects will be subject to the 15-year limitation period that we looked at earlier for projects that complete after June 22, so after the Building Safety Act came into force. But the 30-year retrospective limitation period that we looked at for those historic projects only applies to section 1 of the DPA, so the provision of a dwelling. But it is something that we see catching people out. So it's an important point to consider in respect of the particular project that you're looking at.
Thank you, Steph. And as ever, if you do have any other questions and you didn't post them today, feel free to get in contact with any of the speakers. In the meantime, I'd just like to thank everyone for attending today. I hope that you found it useful and informative. We'll be circulating a feedback form shortly, and as ever, we'd be very grateful if you could take the time to fill that out and provide us with any comments that you have. There's also, as you know, a recording of the webinar, and that'll be available on Watson, Farley and Williams's YouTube channel next week. If you've dialed into the webinar, could you please let us know by emailing events@wfw.com to say that you attended. And I guess I'd just like to wish everybody a great day. Sun is certainly shining where I am, and I hope it is for everybody else as well. So goodbye, everyone, and thank you once again.